Without further time taken with introductions, I want to just introduce one more person, and that is Laurie Ers. And Laurie Ers is the director of the Innocence Project for Justice here at Rutgers Law School, and her story is truly remarkable. And for those of you in law school, it's worth finding her someday and talking to her, because if you ever think, how am I going to live my dreams? Just talk to Laurie for 5 minutes and you'll say, okay, that seems easy enough, because she makes it look easy. Because literally, this woman graduated law school just a few years ago, having come to law school from a completely different career, but from a volunteer service devoted to anti-death penalty and innocence work. And she said, I'm going to make it happen here at Rutgers. There should be an Innocence Project. This is the perfect place for it. And I'm going to take my spirit, my dedication, I'm going to apply it to the faculty here and the students and get something going. And in fact, she has gotten something going. And, you know, the example is yesterday my phone rang. And I answered the phone, and it was this, you know, we've got a call from an inmate from a correctional facility. Will you accept the call? And I said, sure, I'll accept it. And it was a client of Laurie's, a client who may be just minutes away from being released, who may be having the opportunity for a new trial. And what struck me about this client was that actually the first call wasn't yesterday. The first call was at the beginning of the week. And I said, listen, I know about you. I know about your case. Laurie's on trial this week. And I haven't spoken to her today, so I don't know what the updates are. But what I'd like you to do is I'd like you to call me back tomorrow, and the next day, and the day after. And every day I will accept your call, and every day I will give you updates, because I know I can't pick up the phone and call you. And he said, I really don't want to do that. And I said, why? What's the downside? And he said, the downside is all the time that I've spent in prison. All the time I've spent in prison where nobody wanted to listen to me. All the time I spent in prison, and I'm innocent. And I'm afraid that if I call you every day, that you won't want to hear from me anymore, and you're not going to work on my case, and I just can't afford, when Laurie's done so much for me, to lose you at this point. You know, I just said, please, you know, that's what we're here for. You've got to call us. You need to know about this. This is your case, and we're working on this for you. And those are the kind of relationships that Laurie has established. That's the kind of project that she's developed, one that's working on behalf of innocent people in prison. And I'd like to introduce with great pleasure, Laurie Ers.
Marcia, for all those wonderful things you just said, how much should I write the check for?
Buy my book.
I don't see any judges in the audience, and so I'm really very grateful for that. So I can speak now uninterrupted by colleagues with objections and orders to sustain by judges, so thank you very much. I'm pleased to be here to inform you about the birth of the Innocence Project. And it is very important, as Marcia described, because it will basically give you an opportunity to see what one person can do with the help of many other involved and interested individuals in helping to create a project. Rutgers has a widespread reputation for offering one of the most comprehensive clinical programs in the country. So when I transferred to Rutgers to finish my law school education, I saw a perfect opportunity to bring an Innocence Project right here in Newark, New Jersey. My inspiration came well before law school, and it continued throughout my first 2 years of law school until I came here to the Rutgers School of Law. I had worked on an Innocence Project with a major law firm in New York, and it became my inspiration. So I took my passion and I brought it here to Rutgers, and Eric Neisser allowed that passion and my dream to materialize, and I am very, very grateful for that. I've now watched my colleagues, including Marcia, become very involved in the Innocence Network project, and I see the enthusiasm that runs through her veins, the same enthusiasm that I had when I first started. I became involved in wrongful convictions in 1993, and it was at a time when DNA testing was still pretty new. It was a time when related exonerations were increasing throughout the country, and DNA exonerations were becoming accepted, not only through the courts, but generally through the public. And this was evidence of actual innocence. It was also at a time when DNA legislation was signed for the first time by a governor in Illinois, allowing DNA testing by inmates to prove their innocence. And on the same day that that bill was signed, it was a day that the state of Virginia executed a man who professed his innocence for at least 10 to 12 years, a man who had requested DNA testing in order to prove his innocence. That request was denied, and I watched literally as politicians in the courts misstated facts, and a web of deception was woven around his case. Despite requests from the Pope and Mother Teresa, the Italian and the European parliaments, his request for a simple test was denied. But after that, I witnessed a fast and ever-growing change in our legal environment, which was spearheaded by Barry Scheck and embraced by lawyers, investigators, and scientists, laypersons all over the country. I saw DNA legislation ignite, and I followed numerous exonerations over the past few years. And I watch now as the Innocence Network has developed all around the country. The network is designed not only to identify and free those individuals that are wrongly convicted, but it's also to recognize and improve the flaws in the judicial system, affecting change in legislation and policies, and educating the community about our findings. And what I am referring to now is what Barry Scheck now calls the civil rights movement. One embraces the essence of what we all stand for, which is truth and solidarity. As a criminal defense attorney, I am fortunate enough to be able to see the inner workings of our judicial system. It is, for the most part, a strong and fair system. But like anything else in the world, it is not without its shortcomings. And unfortunately, those shortcomings take the lives of innocent individuals and they turn them upside down, affecting their families and their loved ones. To me, nothing is more egregious than to be innocent and languishing behind bars, now professing your innocence as a convict upon deaf ears. 3 years ago this spring, I approached the acting dean of the law school, Eric Neisser, with an idea. Having litigated at least one innocent case that I'm aware of, Eric greeted me with a smile and warm approval and gave his blessings to launch the project. And it was Professor Frank Askin and Charles Jones who I worked with to coordinate the project. Currently, we are litigating 3 New Jersey cases. These 3 cases are actually our first cases that came to us about 2 to 3 years ago. I will, just for a moment, give you an idea. When a case first comes to the project, it's a case that needs extensive review. It involves an investigation. It involves a thorough research of the record. It involves an effort to ascertain that it clearly is a meritorious claim of actual innocence. Now, for the first time, I will release the names of those 3 individuals whom I've identified in the state of New Jersey, whose cases we have accepted and who we feel have strong cases of innocence or should be allowed to prove their innocence through the advanced technology of DNA testing. Ricky Williams. Ricky first came to us almost at the beginning of our project, and he strongly professed his innocence. And upon a thorough review, we accepted his case. After his arrest in May of 1989, Mr. Williams spent the next 12 years of his life while incarcerated trying to prove his innocence. It was with our help and through the cooperation of the prosecution that Ricky finally found the evidence that he sought for so long. The rape kit was sent to a lab for testing, and Ricky's health worsened. In fact, in the middle of DNA testing, he died. Unfortunately, this past summer when that occurred, he made me promise that I would continue with the project to seek his exoneration despite his death. The issue is not only important to Ricky and his family, it is important to us all, for the general public has become keenly interested in the pursuit of justice and fairness and identifying those cases where an innocent person has spent years behind bars for various reasons, including false allegations or mistaken identifications, as in this case, for there was no physical evidence linking Mr. Williams to the crime, nor was DNA testing available at the time of trial. Currently, we are seeking his exoneration despite his death, and unfortunately, we have to do so through the courts because the prosecution's cooperation ceased upon his death. But I quote, and I'm going to quote from State versus McDonald, and I'll spare you the full quote because I don't need to do that now. But it's a very important quote from a New Jersey Supreme Court case, of State versus Gartland. And I quote now, "It may be that the defendant in this case is in the hands of God. However, the responsibility for resolving the legal uncertainties left behind is squarely in the hands of this court. It is not the defendant's death which is moot, because the decedent did not take the potential errors of our judicial system into the grave. These potential errors remain behind to perplex and confound the defendant's relatives, families, and the legal system." I hope Mr. Williams has solace in knowing that his claim is continued to be pursued. Secondarily, we have John Russell. Mr. Russell came to us for the same reasons, to clear his name for a crime he insists he is innocent of, yet was convicted and spent years behind bars. The procedural posture of this case is quite different because Mr. Russell has already served his time, but yet he faces liberty restrictions due to Megan's Law and other obstacles in his way. He also faces the stigma of a wrongful conviction. He too seeks DNA testing to exonerate himself, and presently the prosecution is searching for the evidence in order to honor his request. And finally, a very, very important case that came to us in the very beginning. A gentleman by the name of Earl Lee Johnson. Mr. Johnson was convicted of kidnapping and sexually assaulting a 15-year-old girl in the city of Newark in 1988. From the moment he was arrested, he professed his innocence, and he begged for someone to listen to him for the past 14 years of his life while he was incarcerated. He wrote to numerous individuals, and you can only imagine how those letters of request, one after the other, fell upon deaf ears. Why not? Many people claim that they're innocent in prison. Why should we listen to one? Well, we did. We did a thorough research of his record, and we found things in that record which were astonishing to the students that worked so hard with me to try to do what we could for Mr. Johnson. Mr. Johnson's claim of innocence is supported by none other than his accuser. There is absolutely no physical evidence to link him to this crime whatsoever, and in fact, the medical evidence in this case supports the accuser's, the alleged victim's recantation. She bravely came forward and admitted that she fabricated an elaborate story to the authorities after she was arrested. For her own reasons, that's fine, but she is now very cooperative in helping to right this wrong. Although the sole evidence against Mr. Johnson has been destroyed, he must await justice through the courts. There is absolutely no other evidence other than her testimony linking Mr. Johnson to these crimes. And now, with great remorse and having sent an innocent person to prison, his accuser is trying to make it right. As in all of our cases, I believe it's important to first approach the prosecution. And we have been successful in every instance, except maybe this one, in gaining their cooperation. Initially, the prosecution was receptive and showed an interest in conducting their own investigation into this compelling new evidence. But when the case landed on the desk of the trial prosecutor, a different approach was taken, and she wasn't interested in interviewing the victim at all. Unfortunately, this is one of the obstacles confronting defense attorneys litigating actual innocence cases. It is revealing of a greater interest in protecting the prosecutor's verdict than ascertaining whether a gross mistake has been made, and here, quite frankly, is where criticism of the judicial system is justified. When discovering the truth takes a back seat to personal stakes, the vehicle becomes more complicated to freedom than is absolutely necessary. A good faith effort is all we want and all you should want in order to ascertain the truth. I am still hopeful that the prosecution will re-examine Mr. Johnson's case and that an effort will emerge to discover the truth. As a result, Mr. Johnson's case is currently being litigated in the courts. We are currently investigating other cases of actual innocence, some in the state of New Jersey and some outside of the state of New Jersey. And I want to thank at this time my students, and I see two of them right in front of me now who have given me their time and dedication. And if I can just give a little bit of my passion to them or anyone else in this room, then I know that I have done my job. Now you're tired of hearing me speak, I'm sure, and you want the keynote speaker. Well, without further delay, I'd like to introduce a dear friend of mine who has served as an inspiration to me and my work in this field. She is the author of Dead Man Walking and has been nominated for the past 4 years as a candidate for the Nobel Peace Prize. She serves the public interest far beyond what is ever expected from any human being. This person has also been with me during some very memorable moments of my life. She is Sister Helen Prejean.